colleagues further, if that's okay. Thank you very much. So, Honorable Beasley and Honorable Nilmay, thank you so much for your patience, and Honorable Skosan, thank you very much I understand that there has been a trade-off being done. I don't know what the deal was between Honorable Beasley and Honorable Nilmay, but Honorable Nilmay will go first. Can I please ask colleagues from Ekurhuleni, and I think you've been good so far, can we give concise answers? The members are under time pressure from the chair to ask as many questions as possible in a 10-minute period so that everybody gets a chance. So can we please do that? Honorable Nilmay.
Thank you, Chair. Good morning to you. Good morning to our colleagues from Ekurhuleni, to my colleagues and to our visitors from Kenya. Chairperson, yes, this was a metro that was one of the first coalitions in local government. And at that stage, there was quite a lot of stability. And I do know in my other lifetime, I did many study tours to Ekurhuleni. My questions today are going to be with regards to the property fraud. So I'm homing in on to property fraud that was uncovered during this audit. The SIU had identified an attorney who processed the transfer of 208 municipal properties without being mandated by the city. Have you, as a city, filed a formal complaint with the Legal Practice Council to have this individual disbarred? And more importantly, who within the city's property real estate development provided the physical files and internal documentation required to facilitate these fraudulent deeds, the fraudulent deeds and office transfers? The question to follow up on that is, what actions have you as a municipality taken in response to the SIU's findings on the unlawful sale of over 200 properties? Have the culprits been charged yet? And still on the same issue, what systems have been put in place to prevent future fraudulent property transfers? And how is the municipality ensuring restitution for affected parties? That is my first set of questions. Thank you.
It is a direct interaction between you and the member, so you don't need to come back to me. You just have an exchange. Thank you.
So we're just checking whether we take questions or we.
No. The member has got 10 minutes to have an interaction with you. So just keep answering.
No, thank you very much. I'm sure the officials will deal with the technical, because up to now the report is yet to be processed to the president, and as a political leadership we are yet to receive the report. Safe to say that this was proclaimed in 2004. 2024, like 2 years back. The president, the premier, they did touch base with ourselves, but once SIU, they then get into the environment until they complete their work. Unfortunately, we don't have a site or even to touch base with them until just recently, I think now in March, and I'm sure the officials, they will then indicate how far is the work, how far are the recommendations before the report can actually be given to the president, and then we can, and then as a political leadership, be able also to make firm comments. But acting city manager.
Thanks, Chair, and thanks to the members for the question. I think we may not be able to answer all the questions. Safe to say, firstly, that the cases have been opened by the SIU, and the SIU is following through on those cases. Just to indicate, Chair, obviously it's the SIU that's leading the case. So the private conveyancers, as well as the private real estate agents and the alleged officials in the provincial government, Human Settlement Department are subject to the investigation. And I think some of those remedial actions in terms of the Law Society and so forth would be taken up. As it relates to the city directly, Chair, it's only one official that was implicated on our part by SIU, and we are engaging with the SIU on that because that's the only part that the SIU has released to us, because the investigation remains confidential, with the exception of the systematic recommendations which was released to us. So I think in due course we'll be able to get full information from the SIU chair. I would not want to necessarily make a remark in terms of the restitution or the justice for the victims to the scam up until we all have full details, Chair, because we may not know issues around colluding and everything else in terms of that land grab, Chair. I think on that, Chair, I must also indicate, Chair, part of our own internal controls, we have done two things. Firstly, we have budgeted to do land audits in the new financial year, because the city last did a land audit in about 10 years ago or so. So it's been a while since we've done land audits. So we have budgeted for that. All things being equal, Council will approve the budget at the end of May, and we'll start with the land audits in that regard. The second thing that we did when this matter was first informed on us, we then entered into an MOU with the Department of Human Settlements to try deal with some of these specific issues in relation to closing the loophole to when land is being disposed and it's land that is owned by the province or is land that is owned by the city, so that at least both parties have got the relevant accredited officials who are part of that process, instead of just allowing real estate agents and conveyors who collude with the people allegedly at provincial government human settlement. So those are the two things that we have done in the interim. We, like yourselves, Chair, and the rest of the communities in the area, we look forward to the SIU reports. Thank you, Chair. I hope that was precise.
No, thank you. So there's two follow-up questions to this. And the one is, were you notified by the provincial government on human settlements with regards to this? So who actually found out that there had been this fraudulent activities happening? The second question is, in fact, there's two more. Have you identified the officials? Because if you're waiting for the report and the SIU to come with all the information, surely you would have identified which officials are involved, and would you have placed them on suspension, a cautionary suspension, pending investigation? And the legal practice, the attorney, who was the attorney that actually processed the transfers? Has this attorney been a formal complaint been sent to the Legal Practice Council to have this individual disbarred or blacklisted? Because this attorney could still be carrying on practicing within the Gauteng precinct or in South Africa. I think that is one of the most important things. Adding to that, you had mentioned, obviously, the SIU had referred. So obviously, why I'm asking you, do you know the officials? Because 208 criminal and fraud cases are now with the NPA out of this investigation. So what is the city doing in tracking the progress of these cases, of these referrals? And how are you ensuring that none of the implicated individuals are able to exploit municipal systems ever again?
No, Chair, I think I had indicated, Honourable Member, that we have not received the full report. We'll confirm the details of the official, so would not even know, the process that the SIU is currently undertaking, Chair. So I think, as I indicated, Chair, that part remains confidential. And these aspects that have been put to us that we are engaging directly with the SIU on the official that was in Twingo. And as to who was the initial whistleblower in that regard, Chair, I think that also is information that we don't have at our disposal. Thanks.
Thank you, Chair. The only challenge that I have that I'm worried about is that there are officials then still in your department, either covering up or carrying on, or I think somewhere you need to get together and find out exactly where the case is, who is involved, because one can't actually just say, well, it is over there, parked it. But there are 208 criminal and fraud cases that are with the NPA. You or the city manager and the mayor definitely would need to know who are these cases or who are the officials. They cannot still be in your municipality. You already have the Matlanga Commission with your Metro Police. Now you've got your property. And this is also regarding the Villa, I don't know how you pronounce it, Villa Lisa property scandal. So, I mean, this is the other area. You need to be on top of your game with regards to knowing who is involved, who else is in the institution, so that you can actually stop whoever is part of the syndicate going forward. Thank you.
Honorable Nilmate, do you have any other? Because your time is up. Are you done? Okay.
We accept that, and as I indicated, the two internal controls that are in place, the MOU is already in place, as well as the land audits, all things being equal, that will start after the new budget is approved, will help us, and including the outcomes. But we do accept that guidance from the Honourable Member. Thank you.
Thank you very much. Honourable Beasley.
Thank you, Chair. Greetings, Ekurhuleni, and greetings, Kenya. Welcome. You've been giving us a hard game in the sevens lately, so it's good to see. But yeah, welcome, and yeah, good to have you. Good to have you, and hope we can do a study tour to Kenya sometime and see you guys asking all the questions. But welcome. Your Chair, I'm just going to hone into the contingent liabilities. It's obviously a huge concern. The contingent liabilities are sitting at 1.2 billion. It is something that the AG has mentioned, and we've seen it in the road accident fund, where the road accident fund has used government money to defend and defer legitimate claims. So my first question is, who's actually making the decision to actually fight these matters in court? Who actually makes that decision within Ekurhuleni at the moment? And who's giving you advice in that regard?
Thank you. At the moment, our legal department is the one that is actually assisting us in fighting these cases, but obviously it's through consultation with the department, because these matters arise from different departments. Then, based on the submission from departments, the legal department, together with the risk, they assess whether do we really have a case to fight these cases. Our legal department, we also have contracted services where we hire external lawyers that actually advise us on these matters.
Yeah, that's fine. And then I'm just going to hone into to 4, if you don't mind. I don't know if you've got the list in front of you, but if you haven't, there's 2 big claims for pension funds money not paid. The one is for 51 million and the other one's 101 million. Claims for monies due to pension fund. City of Ekurhuleni is defending that matter. surely that's not one individual for 101 million and 51 million. If you can just give some background to that, please.
I think, Chair, on this one, we have to still get the details on the 101.
I think the MMC would want to come in, but if you are also, if you are referring to one of the NHS, just indicate which one so that we are able to then track it and then give it to him. But MMC, you need to come in. Thank you.
Through your chair, I'm not sure if it's related to the Germiston Municipal Retirement Fund, because it's a fund that was existing prior to the establishment of the City of Ekurhuleni. And part of the condition that was agreed to at the time is that when the fund performed below its anticipated target, the difference will then be paid by the municipality. And we think that it is an unfair provision because the Board of Trustees, they have the fiduciary duty to oversee the investment of the fund. And like any other fund, if it performs positively, the dividend gets to be appropriated to the members. So as if the fund is performing negative, members should take the negative effect. But unfortunately, there was a provision that was agreed to and signed in that if the fund performs lower, whatever deviation, then the city must pay. And it's something that is unsustainable. And the city has contested it right up until the Constitutional Court. And I know that there are engagements between the fund itself and the city to try and find an amicable way of dispensing of that provision, because it can't be that when the fund is not performing, then the city is liable to pay for the difference. It departs from what the other funds are doing. I think it relates to that. Thanks.
Yeah, sure. Yeah, but I mean, if you guys have agreed to it, and as we've noticed with the RA, if they keep defending to the Constitutional Court and they keep losing, and it's using money, ratepayers' money. So it's just something to be conscious of. It's just, you keep using ratepayers' money, you keep losing, eventually you got to say, well, we've lost this case. Then there's also another one, summons issued for outstanding service charges. COE is defending the matter, 280 million. I presume, can somebody just give background to that? I mean, 280 million is massive for services, outstanding service charges.
Yeah.
Yes, on the 280, this is actually a dispute between our customers and the city based on the amount that has been charged in the past.
So is it one individual customer or?
No, it's various.
Yeah,
It's various companies, because it's not the ordinary citizen. It's companies. So we've combined all of them into 280.
And have they grouped together in one lawsuit, or is it like a class action, or is it individual?
It's individual, but for the purpose of disclosing, in terms of the line items, we include them under one line item.
And then another interesting one here, the company is objecting to the tariff COE charge for electricity. If you can just explain on that one, 90 million.
This one, because as we know, that companies are charged different tariff from the resident. So there are certain companies that have come forward to the municipality to say the tariff that have been charged for the previous financial years are incorrect. And in actual fact, the city is supposed to reverse those tariffs. But as we know that all the tariffs that we charge the companies are actually approved by the council, and they are through public participation. So on this one, we are confident that these particular customers has been consistently charged the correct tariffs. And in cases where we were incorrect, normally without even defending the matter, we do create a credit note to those customers. So on this one specifically, we are confident that we've been charging them the correct amount.
Because it does say the company, it doesn't say the companies. So are you saying it's many companies?
No, company.
One company.
Yes.
It's a massive amount, 89 million.
It's a lot. If Chair, you can look at the amount of money that we charge some of our companies, it's way more than this. Like the monthly bill on big companies, especially these manufacturing industries.
Sure, yeah.
Maybe just through you, Chair, the City of Ekurhuleni is an industrial area, and we have a lot of large power user accounts. So 208 million might look big, but we do charge a lot from companies. And I think rightfully what the acting group CFO is saying is that we do have a provision for any customer, for that matter, to come forward and present a dispute on the basis of their factual information. And that gets to be reconciled with our own records. And rightfully, where we are found wanting, a credit journal gets to be passed. It's a similar thing with those that are contesting the property valuation. We have a Section 49 process of objection. They can come in, object on the basis of the 3 independent valuation, and on the strength of that, a decision gets to be taken. So it's not an extraordinary thing. Accounts gets to be disputed. I think the question is that, do you have a process to address the dispute? And of course, some of the companies, they have an appetite to litigate, and we don't have a choice but to defend ourselves in that regards. Thanks.
Sure. Have I still got time left, Chair?
One more set of questions.
Okay, just some clarity on this 5. Was it 5 billion or 2 billion that you said? And I couldn't hear you because you're talking to the chair, and was it 5 billion?
2.5.
2.5. That's where I get confused with the 2 and the 2.5. But you also mentioned that there were suppliers who were also putting in invoices. So not accounts being written off, but also suppliers putting invoices, and that hasn't been quantified. Do you have an idea what that might be?
You can just repeat that.
You mentioned that some people were putting in invoices, had access to the database and were putting in invoices and were getting paid. Do we have have you quantified what that amount might be? Because you've quantified the revenue side, but you haven't quantified on the supplier side. That'll be my last question, Chair.
Thank you. The one that we managed to quantify is what was projected there relating to ProServe, of which was around 5 million. This is a company that was not appointed in the city, but was registered in the city and was paid illegitimately so.
Yeah, so just a follow-up question. Are there more potentials out there that you haven't? Maybe sometimes you put their head in the sand and you don't want to know, because someone was asking, how sure are you that there aren't others in the system like that?
We are confident that we don't have that, because after discovering the ProServe matter, we improved our system just to make sure that every single service provider that we pay is actually coming from the CSD. Because with the ProServe matter, at the time, the system we're actually updating the banking details manually. So now we are no longer updating the bank details manually. Instead, every payment we make to a service provider is coming from the CSD. So for us to actually pay into into an incorrect bank account, someone will have to hack the central supplier database. Then we can actually make payments to an incorrect service provider.
All right, thank you very much. We're going to go on a quick